Hi, friends. Hi, friends. We are going to repeat our life because what happened is that the first one didn't work. I have this very fancy streaming software, but it didn't work. So as a result, we're going to start it again. I just had one on TikTok, and I'm going to repeat basically what I was saying before here on YouTube, and then we're going to jump to Facebook. Well, thank you very much for joining. My name is Alena Shautsova. I'm an immigration attorney from New York, and today in our live, we will be discussing the most recent immigration news. What's happening with USCIS? Trust me, a lot of different things are happening in various areas. TPS for various countries, USCIS updates with regard to expedite requests. We're going to discuss those. CB4 law in Texas. What's going on? Why it's important to follow the developments regarding this Texas law. What's going on in general with USCIS budget. And of course, I'm going to share the updates with regard to my going to Washington, D.C. and advocating for immigration reform. I'm going to share some insights as to what there to come before the elections. So thank you very much for joining. Please like, share this stream. Let me know where you're watching from. Hi, Hi, Ali. Hi, Shikal76. Nice to see you guys. And we're going to start. Here, I do not believe on this platform, which is a YouTube supplied platform, I will be able to share certain screens I wanted to share with you, but I will just give you some updates, and later, of course, I will publish some short videos with regard to each of these updates individually, because they're quite important, guys. Well, first of all, you need to know that Burma was designated and redesignated, was designated for TPS, redesignated for TPS, and extended for TPS. If you noticed, this particular administration adopted a practice when they extend TPS for certain countries, they also redesignate such a country for TPS, allowing nationals of the countries who previously were not qualified for TPS to file for TPS. It's so important. So it happened to Burma. Previously, it happened to people from Haiti, people from Ukraine. And it's important. Why? Because TPS is a great status, regardless of the fact that it has temporary in its name. It does not directly, but indirectly opens a pathway for somebody to receive green card in the United States, somebody who overstayed their visa before, who accumulated unlawful presence, who worked without authorization, to receive visa, immigrant visa, or adjustment of status based on an employment petition. Extremely important. How does it do that? Well, it is doing that by travel document. When a TPS holder is applying, receiving travel document and is using it to travel outside of the United States and come back, such a travel holder becomes in legal status, necessary to adjust status based on that employment petition. So that's one huge benefit of TPS. Of course, other benefits include employment authorization and protection from deportation. Very important. So if you know somebody from Burma, please share this good news with them. It can help them to avoid deportation. It can help them to get the green card. It can help them to receive that travel document to travel to any country of their choice. Very good, very convenient. Another important update from USCIS is the fact that requests to expedite, the guidelines with regard to requests to expedite have been updated by USCIS. Specifically, USCIS stated that if you have application, petition, motion pending with USCIS and federal, state, or local government is asking on your behalf for that request, petition, motion to be granted faster, USCIS is going to pay special consideration to such a request. So if you're working for a local government and your work permit is expiring, or you need that I-140 to be approved fast, now is a time for you to ask that local government for a helping hand and expedite your application. But in addition to that, USCIS also improved the guidelines with regard to specifically requests to expedite advance parole I-131 forms. It's important because many of you would like to travel if you have asylum pending, if you have TPS, adjustment of status pending. Usually people on adjustment of status pending do not really face serious issues when they file for advance parole. But if you have asylum pending, it's not so easy to receive advance parole. So these guidelines are very, very helpful to you. USCIS stated that they will consider the following factors when they adjudicate requests to expedite asylum applications. Specifically, when the need to travel occurred and when you filed for that I-131 advance parole application, as well as the processing times. So what's happening is that USCIS is going to look at how soon after you learned about your need to travel, you submitted request for advance parole, if you procrastinated or not, and how long, according to USCIS processing times, it's going to take them to consider the request. And if it's going to take them too long, and you do have a compelling reason to travel, even if it's a personal reason, then they will grant your request. Overall, it's not new information. Those of us who were practicing attorneys or who filed for this I-131s before, we knew this information, but now it's publicly published, which is very important. Now, a very important update with regard to SB4 Texas law. Texas anti-immigrant law. Who's here from Texas? Let me know. Guys, don't forget to like and share the stream. You're going to help me to make my channel more popular. And I will help you by answering your questions for free. So please don't forget to like the stream, share it, and of course, type up your questions so I'll be able to help you out and answer questions for free. So what happened with CBP4 is that Texas passed their own immigration law. They basically got tired of waiting for federal government to act, and they decided to take the matters in their own hands. Under this law, Texas local law enforcement is authorized to arrest, detain someone who they believe is in their state without authorization. And under this law, local Texas judges are allowed to deport somebody, to send them back to Mexico. Interestingly enough, Mexico stated that they're not going to be accepting such people, but that's a whole different story. What is particularly interesting is that immigration enforcement is a function of the federal government, not state government. However, there is a state constitution. Each state has state constitution. And in that state constitution, each state usually has certain articles that allow the state to undertake certain actions if they believe that they're under attack or invasion, basically emergency situation. So exactly that situation Texas used to justify passing of that law. Now, the United States Supreme Court, interestingly enough, allowed Texas to proceed with their plan, not because of the fact that they believe Texas can do it, but in the meantime, while the other lower federal court is considering the situation. So this is a very interesting precedent. You know that Texas is not alone in this direction of passing their own immigration laws. The same is happening in Florida. And who knows who else is going to, which states are going to pass similar laws. So we all are watching for this situation to develop. We're all watching to see what's going to happen. And after the United States Supreme Court stated that Texas may proceed. Lower federal court stated not right now. So it's a very interesting situation. You have to pay attention to that, because imagine this. If every state is going to pass their own immigration law, we're going to face some sort of a chaos in the United States, where the functions of the federal government are now being outsourced to local law enforcement and local judges who don't have federal law training or experience in enforcing such laws. So we're going to see what's going to happen. I think it's a very important development in the United States. It's fairly new to my knowledge. Within the past 20 years, I've never heard of anything like that happening. And we're going to see the history is being made before our eyes with regard to this particular development. Now, one last thing I wanted to give you a certain update about before I'm going to talk about my trip to Washington, D.C., is that you also have to pay close attention to something as simple as USCIS budget. USCIS budget has recently been approved, where they received $300 million when they asked for $800 million or so, and their fees are going up. One of the things we actually pointed out to our elected officials is that there is little to no accountability on behalf of USCIS as to how exactly they're spending this money. And it's why it's important. It's because when USCIS works inefficiently, that reflects on the backlog. Maybe you filed for your family member and you're wondering, why do you have to wait for 15 plus months for your spouse to join you in the United States if you're a US citizen? Maybe you're going through asylum system and you're wondering, why do you have to wait for 10 years just to get a referral to already backlogged immigration court system? And all these questions can be answered by USCIS, but not to me or you, but only if Congress is asking them these questions. So now I'm going to turn to the next topic of the meeting in Washington. I, together with other immigration lawyers, met with our elected officials, and this particular issue of the federal budget and allocation was raised with regard to USCIS, but also the border. What's happening right now is that all these little issues, immigration and money, are tied up together. Everybody on the Hill is agreeing that something has to be done with regard to immigration and the United States border. But then people are in disagreement as to what has to be done. Everybody's talking about the border security and money. But do you know that it takes $157 about per day for federal government to host one immigrant per day, to host them in detention? And last year they spent $2 billion on that. And it takes only $8 per day for alternatives to detention. So now what we were talking about with elected officials is the fact that you don't really have to have new money to try to address the immigration crisis at the border. You can simply reallocate the funds that are being wasted on cases that this money should not be wasted on. And this way, we can make the system to work more efficiently at the border and with USCIS as well. USCIS currently is actively pushing cases, asylum cases in particular, on to immigration courts. Immigration courts have about 3 million cases before them. Immigration courts, who are the ones to address the crisis at the border, because you can be deported out of the United States once you're in the United States, only if an immigration judge makes a decision. So immigration judges simply cannot process these incoming influx of cases because they're backlogged, partially due to ineffective work of USCIS. So all these issues, effective work, effective usage of money, resources, were raised and addressed. And it seems that the elected officials, our congressmen, at least the ones that I met from New York, are very much interested into why we are in the situation where we're at. And they all stated that they will be doing something about this, which is great. Another important issue that we discussed during the meeting was, of course, relating to immigration reform. And I'm going to be very frank with you. When we as a group of attorneys went to our congressmen, we hoped just to talk about common grounds and to talk about little changes that can happen with regard to immigration here and there, such as independent courts, funding for unrepresented children, certain relief acts that will reduce immigration detention. But the first thing that the congressmen, ADs, were interested in is our position on comprehensive immigration reform, which, of course, it came very unexpectedly because, frankly speaking, in this divided climate, everybody already gave up on that, it seems. But it's not the case, it seems. And in fact, perhaps closer to November, we may see something passing. And that something is going to be more akin to the Dignity Act. And as I said, this is just discussion. This is something that I gathered from the meeting. And nevertheless, it's something that's very interesting and exciting. Dignity Act, as you recall, was proposal by the Republicans. It was heavily criticized by Democrats. It was heavily criticized by non-for-profits because it's not an immediate solution for someone to receive a green card if they've been undocumented in the United States, because it comes with heavy fines. It comes with lengthy wait times. It's going to take one about 15 years before they can become a citizen. However, it's something opposed to nothing. In a situation where we have not seen comprehensive immigration reform for like several decades, this would be a solution. It will be something, right? It can also always be improved later. This is something that apparently at least some Republicans are interested in and would consider something similar to Dignity Act, in addition to laws protecting the border, of course, and protecting the border plus budget allocations for CBP staff. All right. So this is just very exciting, and I wanted to share with you guys that not all is dead with regard to comprehensive immigration reform. While the government right now is looking at the bipartisan solutions with regard to the border issue and funding for foreign countries, immigration reform idea is not completely dead. In the immediate future, we may see some changes. What does it mean for you, though, right? If you're here for a very long time, what does it mean? Well, if you truly would like to understand what it means, you have to watch my earlier videos on that. You have to be prepared. You have to clean up your criminal record if you have some. You have to file your taxes. You have to obtain your documents such as birth certificate, marriage certificate, divorce certificates. You also have to make sure that you are a person of good moral character. A lot of these applications, proposals, they require you to be a person of good moral character. Of course, by default, usually it's somebody who simply does not have criminal convictions. But if you volunteer, if you're very active in social life, that would help as well, especially if you had some troublesome past, orders of deportation, fraud allegations, perhaps failed marriages, applications for green cards through marriages, and of course, criminal past. So you have to keep this in mind, that you want to clean up your pathway for this possible changes that may to come. I certainly hope they will come. And again, there is interest between both sides, I would say, to pass a comprehensive reform, not just little immigration acts here and there. And it's a good sign, I would say. It's a very good, exciting sign, right? And again, if you're interested in learning more about Dignity Act, I do have a video about that explains in details what it is. It doesn't mean that exactly that proposal will be adopted, but this is something that Republicans would consider. And now, if you guys have some questions, I'll be very happy to answer them. Hi, Shi. Hi, Ali. Hi, Pella from Cameroon. Hi, Kaka. Hi, what can I do to expedite the decision after my asylum interview? How long does it take for Long Island office? Extremely good question. So, about 30% of all cases that went through asylum interviews are going to be stuck in another backlog. Backlog for the decision. It depends on how long it has been pending, how long since your interview you've been waiting for that decision. But here, a lawsuit would probably help. A lawsuit to force the government to issue a decision to you. But before you're going to consider this option, remember, it is faster for USCIS asylum office, especially the one in New York, to deny your case than to approve it. So if you're not afraid of that denial, if you're not afraid of the fact that you may be transferred to court after the denial, go ahead and with your attorney file that lawsuit, forcing USCIS asylum office to make a decision on your case. If you are afraid, please don't do anything. Don't make your situation worse. Hi, Chuta. Hi, Alena. I'm from Pakistan, and now I'm in Malaysia. So how can I apply for USA for business or job? Well, you would start your research by learning what opportunities are out there and which one may be a good match for you. For example, E2 visa or L1 if you're a business person, family immigration if you have family members in the United States, or employment when you find an employer who is sponsoring you. Those would be typical ways for somebody to file for a visa to come to the United States in a green card basis. Hi, Duke. Hi, if my newly married American citizen wife didn't file tax for last 2 years and has now filed tax this year, can this affect my I-130 that she is due to file? It doesn't affect I-130 per se. What it affects is Affidavit of Support Form I-864. Your U.S. citizen spouse who is petitioning for your green card or that immigrant visa quota, right, would have to show that they have sufficient funds to do so. And typically, anybody who is living in the United States, residing here, and working must file taxes. It does not mean that you will owe any taxes, but it means that you have to file and comply with filings, unless you are exempt. So what needs to happen in this situation is that your spouse should consult with an accountant or CPA, certified public accountant, and see if she has to submit amended tax returns. If not, and she legally was not under obligation to submit for her taxes, to file taxes, she would just provide such an explanation to USCIS that she did not file taxes for certain years because she was not under obligation to do so. Okay? Typically, an affidavit notarized or sworn under the penalties of perjury will be sufficient. Hi, Tour Tourism. How are you? I have a situation. I have a marriage-based green card for 2 years, but not unfortunately, marriage did not work well. My question, Can I apply I-751 solo? And how's the process going with probably immigration? All right, so what's happening here is that you have a conditional green card based on marriage, but something is going on with your marriage. It's falling apart. Correct. The law provides for an opportunity for you to submit that I-751 form on your own without your spouse. You can do it under 3 bases. Number 1, the marriage was real but resulted in divorce. So by the time you submit that I-751, you must be divorced. Number 2, your marriage was real or is real, but you've been abused during the marriage. And number three is that during the time of your conditional residency in the United States, certain grounds occurred, certain conditions, that now, if you are removed from the United States, you will face extreme hardship. Typically, you would file, if you qualify for that abuse ground, under all 3 grounds that I-751. Why? Because if I-751 is denied, you will be placed in removal proceedings. And in removal proceedings, an immigration judge may review the denial, but only on the grounds that were previously vetted by USCIS. So, not to waste time, you would like to cover all the grounds, not afraid, but anything can happen, with an understanding that if something does not go your way, you're going to preserve your right to ask federal judge, immigration judge, to review the grounds of the denial for that petition. That's what you need to do. All right. If you need my help, please call my office to set up an appointment. I'll be very happy to go over your case, see what's the best situation for you, how to address this. Hi, IK. Hi, Alena. My cancellation or removal was terminated without prejudice. What should I do next? Cancellation or removal is terminated without prejudice means that you do not have anything pending unless there is something left pending in immigration court. And you're not going to have that work permit anymore. Because I do not know you and your circumstances, I cannot tell you what you need to do next, okay? But termination means that there is no case anymore. I just hope you understood it prior to agreeing to the termination. Hi, Monterog, is there a way to expedite my pending I-601? Sure. You will have to submit expedited request to USCIS. We just covered the updated guidelines for case expedition, and please review them before you file your request. Hi, Trudy. What are the supporting documents for adjustment of status through T status? Is declaration needed? Yes, sure. It's very easy, guys, to see what is needed. You just need to review the instructions for T visa and instructions for adjustment of status. A declaration of certain sort will be needed to explain that why you cannot return back to your home country, that you're helpful to the law enforcement, or that law enforcement didn't reach out to you, things like that. I would say work with an attorney if you can. If you cannot afford a private attorney, there are non-for-profits that do take such cases and will help you out. Hi, Naveed. Filing adjustment of status for my parents. And again, guys, if you like this live, please don't forget to like and share it. If I answered your question, especially say hello, say thank you. I would really appreciate that. Hi, Naveed. Filing adjustment of status for my parents. My parents' marriage certificate was registered several years after marriage. Is it an issue? My mom, because it's registered just the day before her first birthday, will that consider late? I'm not really sure what's happening, what's happening here, but typically USCIS is paying close attention to authenticity of the documents. If they believe that authenticity of a document is concerning, they will ask you to produce secondary documents to address that. So I'm not sure if this situation is typical for your country, where the marriage certificate is registered later than the official ceremony. I think what needs to happen is that you would need to maybe show that document to the attorney first before you're going to file something, and then you will be able to, have a better answer to your question. Hi, Sheila. Can an undocumented individual invite a parent or sibling as a tourist? Yeah, sure. I mean, listen, your invitation is not even necessary for a parent or sibling to apply for the tourist visa. You have to know that, right? So if I would have to consider the situation, I would say just don't submit anything to the consulate. Your relative is going to file that form DS 160, and they will have to disclose that you are here in the United States. And what's going to happen is that the consul is going to make a decision whether or not to give them the visa. However, you need to know that the fact that you are here undocumented is going to be considered an adverse factor by the consul when they're making their decision. All right, this is how it works. Well, guys, thank you very, very much for watching. Thank you for your likes, sharing. Thank you for the questions. I hope you enjoyed this live stream. And don't forget to subscribe to my channel. And I hope to see you soon.